So don't come back here, be hearing any contact whatsoever, or you'll sit in jail. It says Anthony Buford.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Buford, who is on to the podium.
Okay. Your name?
Anthony Buford.
All right. What are we doing?
Your Honor, it's my understanding that we are here today for a bond violation as well as the PCC. Mr. Buford indicates to me that at the last hearing he did admit to the violation, but it's not clear to me from.
Well.
So then with that, we are asking if we could go to sentencing on the violation. At this time, he has been in custody. Am I talking over someone? Okay.
No. All right.
Okay.
Go ahead.
At this time, we are asking that the court grant him a sentence of 8 days with credit for 8 days served. Mr. Buford has indicated that he is very clear and understands how serious the no contact order is. He has learned a lot from this experience.
Didn't understand that before?
He understands very clearly how serious this is. It is my understanding that there was nothing threatening or of that nature in the calls. He has a child in common with the complainant and had just hoped to hear some words from his daughter. With that, we are asking that you sentence him to this time because, again, he understands that this is very serious, that he must abide by the no contact order, that there are no exceptions for contacting her in order to contact his daughter. If the court sees fit for any alternative for him to contact his daughter, then he, of course, would appreciate that. But if there is not an alternative, then he will just not have any contact and focus on other things, such as he does have a job, which he was able to speak to and be assured that they would hold it open for him a little while longer. In addition, he has family support. He's been in communication with his mom, and he indicates, and he did last time, he did appear in court in person, and he will continue to appear in court. So we are asking that Your Honor consider that. He is very apologetic, and again, is very clear about the serious nature of court orders and that he must follow them. Is that correct, sir?
That is correct, yeah.
Anything from the people?
I'll leave it in the court's discretion. My only concern is that these calls were made from other parents, not his own parents. So I'm concerned that James trying to hide the fact that he's calling the victim by not and then given the nature of his regulation, I have concerns for her safety, given that he violated his At
this point, the defense is taking a smart legal approach. Instead of arguing about whether the bond violation happened, the attorney is trying to convince the judge to give the defendant a lighter sentence. Once someone admits they broke a bond condition, the focus is no longer on proving what happened. The goal is to show the judge that the person can safely remain in the community under the right conditions. The attorney keeps pointing out that the defendant has accepted responsibility, has a steady job, has support from his family, and says he will follow the no-contact order from now on. These are all things judges often consider because they show the person may be able to change. But there is one problem with this argument. Saying the defendant only wanted to talk to his daughter may explain why he acted, but it does not excuse breaking a court order. Judges expect their orders to be followed exactly, no matter the reason. Did you notice the defense never claimed the defendant misunderstood the order? Instead, they admitted he now understands it. That small difference is important because it shows responsibility while asking the judge to believe the same mistake will not happen again.
I'll sentence the defendant in this case on the bond violations. You said he's been in 8 days.
Yes, Your Honor.
Sentence him to 10 days, credit 8 days for violation. Then his bond is his previous bond is then reinstated with its conditions. You understand that, young man?
Yes, Your Honor.
So don't come back here, be hearing any contact whatsoever, or you'll sit in jail. Am I clear?
Clear, Your Honor.
All right. What am I doing with the case?
We'd like to set it for a preliminary exam, please.
Your Honor, in regards to the bond, was there a judicial provision?
There should have been initially a GPU tether division, I thought. Were you on a tether?
Yes.
Sir.
I'm sorry.
Tether will be reinstated.
Thank you, Your Honor.
And so all of your discovery is complete, Ms. Gaines?
Yes, that's my understanding.
And the people have their witnesses available the 28th. Preliminary examination in this matter will be set for July 28, 2026 at
9 a.m. for you.
it's going to be noon, right? At 12 noon before me.
12 noon? Thank you, Your Honor.
Thank you.
Stephanie Cannon on behalf of Mr. Brady. Please state your name for the record, please.
Matthew McLean.
Your Honor, we are asking that this be set for the exam, but in addition, we'd like to readdress bond with the court. The court remembers last week approached on his case, and we discussed how he had been communicating with family members and asking them to let her know that the complaining witness, that she loves him, or sorry, that he loves her. And the court set it aside 1 week. Your Honor, we're asking that you release my client back on a PR bond, or if at the worst, a very low nominal bond. His father is driving up from Indiana to pay any bonds that the court may try, if the court chooses to put bond on him. But he is, if I remember correctly, no communication was actually ever had with the complaining witness. It was just in the family member I spoke to.
Through third parties, as I recall.
I spoke to the father. The father was very clear that he never even told the young lady that he said he loves her. He didn't do that. He would not do that. And my client since then has had no communication with her. He was released for like 4 days.
2 days.
2 days.
I got in despair.
And he had no communication with her, so much so that he asked me if he could have somebody do a welfare check because nobody had communication with her. Your Honor, my client understands he cannot speak with her. He is not going to speak with her. He's asking to be released back on Tether at this time. In the alternative, and I did send somebody to talk to my client about this, understanding that at the time, both he and the complaining witness were intoxicated in their own home. If the court is not inclined to just let him out on PR bond, could we do bond or PR to treatment if the court does not want him just released?
Discovery is complete.
Yes, Your Honor.
We'll have their witnesses available the 28th.
Sure.
Preliminary examination will be set for July 28, 2026 at
12 noon with you.
12 noon before me. Is there a response as to the bond argument?
Your Honor, I'll leave it in the court's discretion. I will note for the court that in some of the calls he makes to both his father and his mother, there is talk of, did you speak with the victim? And they say, yes, I believe that's the mother that he was contacting. So I do have concerns about that. I do think treatment would be a good idea. There is talk about sobriety within those calls for both the victim and defendant. So I feel that treatment would be a good option for him, given the allegations in this case, what was discussed on these calls.
And he is in the Sparrow program.
Waiting for a bed.
Yes, he was waiting for a bed, so he's not objecting to going to treatment.
I'll release him. Bond will continue as is. I will release upon a PR with other two inpatient treatment.
This hearing is a good example of a judge trying to balance public safety with giving someone a chance to improve. The defense argued that the defendant never directly contacted the protected person and had stopped trying to reach her. The prosecution disagreed, pointing to recorded jail calls that suggested family members were still talking about the victim. Even indirect communication can violate a no-contact order if it looks like someone is trying to reach or influence the protected person. Judge Simpson chose a middle ground. Instead of giving the defendant unrestricted release, he required inpatient treatment. During the hearing, there were several references to alcohol problems, the Sparrow program, and the defendant waiting for a treatment bed. The judge's decision shows that the court wanted to address the issues that may have led to the violation while still protecting the public. Some people may think the defendant should have stayed in jail, while others may believe treatment is the better long-term solution. Either way, the judge focused on reducing future risk instead of simply handing out punishment.
Thank you, Your Honor.
All right, thanks.
I just texted you back. Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Wilson.
All right, I got it.
Your Honor, we are requesting an adjournment. I just received this morning by email approval for visitation with Mr. Wilson. So, Mr. Wilson, I will be visiting you soon. Maybe a 3-week adjournment.
Okay. August 6, 2026, 9 a.m. Bond continued.
And I did receive your letter.
Yes, sir.
When is soon? Because they said they got the approval last time we was on the screen with you, and they keep adjourning it.
Okay.
This is crazy.
Well, them having to get the approval in the manner that they do is, I would say, kind of crazy, but it's okay.
Well, my issue is when they had the approval last time, she should have came and seen me. In a minute, I'm finna request to fire them because they're not doing their jobs.
Sir, why don't you meet with them?
She just said she got a letter and I still ain't got no discovery pack that I requested. Why I didn't get the discovery pack? You don't need no approval to send no mail in. I requested my discovery
process. So I just received the letter this week. There is a special process that the Michigan Department of Corrections has, and it had to be set up. The legal assistant and our IT person sent me an email yesterday saying that they are working and hope to get that discovery out to you today. So that is what's happening. There's a variety of different, we can't send it regular mail. So we're having to deal with a lot of different technology in order to be able to send that to you. But it is in process. It is in process. I requested it as soon as I got the letter.
And we'll continue. Thank you.
The last part of this hearing focuses on a problem that comes up in many criminal cases, but is often overlooked. It involves communication between a defendant in jail and their attorney. Mr. Wilson says he is frustrated because he has not received all of the evidence in his case and feels his attorney has not been doing enough. These concerns matter because every defendant has the right to review the evidence and help prepare their defense. The attorney explains that the delay was caused by jail procedures and technology, not because anyone refused to share the evidence. Judge Simpson handles the situation calmly. Instead of letting the hearing turn into an argument between the attorney and the client, he makes sure the attorney will meet with the defendant and gives them more time to prepare. This protects the defendant's right to effective legal representation while keeping the case on track. Looking at all three hearings together, one clear message stands out. Courts expect people to follow court orders and legal procedures. Good intentions alone are usually not enough to excuse a violation. However, taking responsibility, showing a willingness to change, and following the rules can have a big impact on a judge's decision. What stood out to you the most? Do you think the defendants made strong arguments, or do you think the judges made the right decisions? If you enjoyed this courtroom breakdown, be sure to like the video, share your thoughts in the comments, and subscribe for more courtroom analysis. vidIQ.